It's been 3 years. 3 years since we all came out and said enough is enough with police brutality. And to be honest, I'm not sure we've recorded much progress between then and now. Because even after the EndSARS protest, Nigerian policemen continue to take the lives of many citizens for trivial issues, for making a U-turn, for coming out of a mall, for dancing at a birthday party, for drinking a cup sachet water, for attending a burial, for driving his bus. The list goes on and on. But on this 3rd year remembrance of the EndSARS protest, I want to focus on something which hasn't gotten that much coverage yet. The system. The system that makes police brutality so prominent in Nigeria. It's a combination of an administrative, legal, and political framework which results into a broken policing system. So let's take a look at the gray areas. Now, make no mistakes. The pictures you saw earlier, that's Bolanle Raheem, Gafaru Buraima, Igwe Odinaka, Paul Durowaye, Godsent Obafuozo, and Oliver Israel. They were all victims of police brutality post the EndSARS protest of 2020. That means that the police brutality, which we were protesting against then, doesn't seem to have stopped. In fact, according to Human Rights Watch, a year after the October 2020 protest, Nigeria recorded another 164 cases of extrajudicial killings between January and September 2021. So what we're experiencing right now is not a case of individual bad cops. This is emblematic of a larger structural problem with policing in Nigeria. I remember asking myself and a friend of mine on the night of that 20th of October 2020, how did we get here? How did law enforcement agents, whose duty it is to protect the lives of citizens, turn into agents of wanton violence, acute brutality, and more often than not, punitive death? Attempt to answer this question reveals some grimy truths. 1. The inheritance of a police force that has brutality and civilian repression embedded in its DNA, a crystal clear ineffective system of policing, a culture of shielding erring officers, and more importantly, a legal framework with which the Nigerian police justify their appetite for extrajudicial killings, and the political structure that helps them evade prosecution for this crime. So let's take it one after the other. To understand the Nigerian police force of today, it is necessary to examine its history and structure and the context in which it was founded and operated, particularly during the colonial era. Okay, I'm sorry. I know I sound like a broken record already. Almost every episode of this show so far indicts the colonial era in one way or the other. It seems like I have an infatuation with them. Trust me, I don't. But the truth is, in 1860, British colonial authorities created a 30-member consular guard in Lagos. This is the first organized policing unit for the territory which is eventually to be known as Nigeria. The amalgamation of 1914 was followed by the creation of a unified police force under the leadership of an Inspector General of Police in 1930. Now, there are widely documented evidences of how the colonial authorities used the police force, which is made up of natives, essentially to control local communities and stamp down any uprising against the colonial rule. With this, the foundation of the Nigerian police force brutality, which we're experiencing now, were laid during the colonial era. Because in 1960, we didn't just gain independence, we also inherited the institutions and the culture of the colonial police, which has a track record of brutal subjugation and boundless suppression of civic resistance. Now, post-independence, Nigeria's history of governmental and constitutional instability helps to explain the professional incapacity, the institutional weaknesses, and the criminal culture of the Nigerian police force. Since Nigeria gained independence in October 1960, we've had 8 military head of state. Put together, they jointly presided over a total of 29 years of military rule. During this period, these leaders who came into power through military coup usually would do 2 things. 1, they alternately use the police force to enforce their authority, largely because only the police force had a nationwide presence across the federation. 2, in order to prevent their involvement in coup, successive military regimes dismantled the infrastructure of the police. They also failed to fund the police adequately. Then, with the revision of the Police Act in 1967, they centralized operational control of the police in the hands of the head of state. Together, these measures politicized the force and degraded its operational effectiveness. In fact, as far back as 2008, a presidential committee on police reform was formed to look at the rot in the police force. It was headed by this man, retired IGP MD Yesufu. In his report, he specifically noted that successive military regimes erroneously regarded the Nigerian Police Force as a rival power base to the armed forces, and as such, did everything they could to undermine its capabilities and effectiveness so as to sustain their political hegemony. The situation wasn't so different even under civilian rule. Civilian government officials have used the police for partisan purposes, including electoral fraud and political violence. So with this approach, by the colonial and post-colonial military and civilian regimes, the Nigerian Police Force then evolved into an institution that is firmly rooted in a culture of violence. Meanwhile, at the receiving end of this violence and brutality is the ordinary Nigerians. From the Apple 6 victims who were shot dead by policemen in Abuja as far back as 2005, to the young man who was shot in front of Wetland Hotel in Ogele, Delta State, which actually sparked the EndSARS Protest of 2020, to Bolanle Raheem, a pregnant lawyer who was shot under Ajah Bridge on Christmas Day last year. Nigeria police often operates with absolute impunity. Now, we've got to touch down on the basis of this. How are Nigerian policemen trained to use firearms? Usually, police recruits are trained in a 6-month training period in a police academy. Subjects for the training include basic police duties, elementary law, police administrative orders, weapons drill and use, among others. Of all of this, the police recruits are engaged in weapons drills and use only twice a week over the period of their training. According to an investigation by Vanguard newspaper, it affirmed that apart from the training acquired by these recruits during this 6-month period at the police college, a good percentage of them never went back to their shooting range to perfect their marksmanship. The report says most killing of innocent Nigerians were a clear indication of a lack of excellent focus and good hand-eye coordination while firing at targets. Most times, these policemen, especially the rank and files, during interrogation, they revealed that they aimed at a vehicle's tire or a victim's leg only to miss the target. But rather than fix this deficiency of firing skills in the force, you know what the police do? They cover up the track. Whether it is for accidental discharge, torture, custodial death, or extrajudicial killing, the Nigerian Police Force have a legal framework to justify all of them. It's called the Police Force Order 237.
And don't forget your Force Order 237. You read it very well, you digest it very well, and you know when you should use your firearms.
Force Order 237, which regulates the use of firearms by the police, is an important part of the legal framework regulating the work of the Nigerian Police Force. Enacted by the IGP, Force Order 237 comprises of 8 paragraphs, only 8. Among other things, Section 3 of the Police Force Order 237 permits a police officer to use lethal force, and I'm quoting directly now, where it cannot by any other means arrest a person who takes flight in order to avoid arrest, provided the offense is such that the accused may be punished with death or imprisonment for 7 years or more. This order also includes when a policeman is attacked and his life is in danger and there is no other way of saving his life. Now let's break that down. 1. To take flight means trying to escape. 2. Lethal force is any kind of deadly force which is likely to cause serious bodily harm or death. So in effect, what the Force Order 237 says is a policeman can use any kind of deadly force, including shooting, when trying to arrest the suspect or prevent the escape of an accused. So far the offense the person is suspected for is likely to carry a sentence of anything from 7 years imprisonment and above or the death penalty. These are called felony crimes. Also, the force order can be used when a policeman is attacked or his life is under threat. That's why oftentimes, to justify extrajudicial killings, the police would say the victims posed a violent threat to the life of the officer. But here's the part they completely ignore. Section 4 of the same act says a police officer would have to prove that he was in danger of losing his life or of receiving an injury likely to seriously endanger his life. It says, and I'm quoting directly now, it would be most difficult to justify the use of firearms if attacked by an unarmed man. It goes on to say, if attacked by a heavy stick or machete, he would have to prove that he could not have disabled the attacker with his baton or rifle butt, and that other means available to him were not sufficient to protect his life. And here's the most neglected part of this force order. Back to section 3C of the force order, it says, the police can use lethal force when necessary to disperse rioters or prevent them from committing serious offenses against life and property. But it also added that 12 or more people must remain riotously assembled beyond a reasonable time before the use of firearm can be justified. Now in section 6, it further explains that fire should be directed at the knees of the rioters. Knees. And again, never under any circumstance will warning shot be fired over the head of rioters. This is the operational doctrine of the Nigerian Police Force on the use of lethal force. But between me and you, we know that the actual reality in the use of firearms by the Nigerian police is a radical departure from what is stipulated by the provision of this act and other extant legal frameworks guiding police conduct. However, Force Order 237 is vaguely employed by the police to justify extrajudicial execution, especially in the case of suspects claimed by the police to have committed a serious crime, such as armed robbery, which carries the death penalty in Nigeria. It is perhaps no coincidence that victims of extrajudicial execution by the police in Nigeria are usually labeled as armed robbery suspects who were either fleeing custody or attacking police personnel. Not only does this label help cover their crimes, it also worsens public fear of armed robbers and creates the perception that anyone described as such automatically loses the right to both life and due process. One of the most unimaginable of this kind of cases is that of the police in Macaroni area of Ogun State, who shot and killed Waliyu Abudu, a wife, a mother, and a poultry farm worker. The killing appeared entirely unprovoked, in the face of mounting evidence from Abudu's family and employers that she was an innocent victim of unjustifiable police homicide. The Ogun State Police Command staged an elaborate press conference during which they branded the woman as the leader of an armed robbery gang. The police refused to release her body to the family for postmortem or autopsy and provided no evidence whatsoever to substantiate their public accusation. Till today, no one in the Nigerian Police Force was ever punished for that woman's death. And she's not alone in this. Many more Nigerians have suffered this fate. And you wonder how. If the provision of the Act on the use of firearms by the police is crystal clear on excessive use of force, why are offenders of the Act within the police force not usually held accountable for their violations? It's simple. The police force is saddled with the responsibility of prosecuting offenders, including its own personnel. This can be traced all the way down to the Nigerian Police Act itself. It was first enacted in 1943 as the Police Ordinance. The Police Act is the principal instrument that establishes and regulates the structure, functions, and powers of the Nigerian Police Force. The Police Act also empowers the police to undertake criminal prosecution. As a constraint on police abuse, the Police Act provides that police officers are legally responsible for any crimes or other misconduct committed by them in the course of their duty, and the Police Act does not exempt any police officer from such responsibility. Now, except when committed in the Federal Capital Territory, Abuja, crimes against persons are state offenses liable to be prosecuted by the State Ministry of Justice under the leadership of the State Attorney General. Although ultimate control of criminal prosecution resides with the Attorney General, most of the criminal cases in the country are prosecuted by the police. Therefore, the Nigerian Police Force is also responsible for investigating allegations and prosecuting crimes committed by its own personnel. And more often than not, they fail at it. There are numerous examples of offending officers going scot-free. A report by Amnesty International documented 82 cases of torture and ill treatment over a period of 3 years and found no instance of a police officer being prosecuted. Instead, officers were transferred to other units, allowed to retire, or even appointed to positions in state government. A classic example is that of this man, James Nwafo. He headed a SARS unit in Anambra State. During his time, several petitions from lawyers and human rights groups detailing his involvement in torture and extrajudicial execution were submitted to the government. At the heat of it, he was merely transferred from Anambra State Police Command to Bauchi State Police Command. However, When the heat died down, James Nwafo was again transferred back to SARS unit in Anambra. And the worst part is this. Upon his retirement in 2018, he went on to become the Senior Special Assistant on Security to the Governor of Anambra State then, Willie Obiano. The governor was compelled to relieve him of his appointment only when his name was repeatedly mentioned by protesters during the EndSARS Protests of 2020. Well, in this fight by the citizens against police brutality, there's been some monumental wins though. Take the case of the pregnant Lagos lawyer, Bolanle Raheem. She was shot dead on Christmas Day last year by this man, Drambi Vandi. When the news surfaced and reports say she was 4 months pregnant when she was shot, huge public outcry followed. The officer was identified and eventually prosecuted. He stood trial for 8 months. And guess what? Last week Monday, Justice Ibironke Harrison found him guilty of murder. While giving the verdict, she said, the court found the defendant guilty on 1 count of murder. You will be hanged by the neck till you're dead. This was a win in the long-run battle between Nigerian citizens and senseless policemen. But it's a win for one battle. The full-scale war is still raging. The Center for Law Enforcement Education, Clean Foundation, conducted a survey on the prevalence of violence in encounters between the police and the public. The survey revealed that 73.2% of respondents had witnessed an assault by the police. 22.5% had been threatened by the police with being shot, and another 14.8% had experienced some sort of assault in the hands of the Nigerian police. And until the issues raised in this argument are addressed, these numbers might keep rising. So you see, the war against police brutality is still quite raging. We can only hope that the souls of countless Nigerians, with the Nigerian Police Force that froze life out of them, rest in peace. Particularly those who paid the ultimate sacrifice at the Lekki Tollgate 3 years ago. Brothers, sisters, we truly hope that your death won't be in vain.